So, welcome back. Today we have defense, environment, polity, economy, social justice, technology. Let's go. So, first of all, we have the INS Aridhaman plus INS Taragiri, nuclear triad complete. So, India's India commissioned INS Taragiri, the sixth and final project, 17A stealth frigate, and INS Aridhaman, the country's second nuclear powered ballistic missile submarine, on April 4. Now, together, these two vessels mark a significant milestone in India's maritime and nuclear deterrence. An SSBN, a ship submersible ballistic nuclear, is a submarine that carries nuclear tipped ballistic missiles and can launch them from the ocean depths. INS Aridhaman carries the K 4 submarine launched ballistic missile with a range of approximately 3,500 kilometers compared to Arihane's K 15, which had only about 750 kilometers. India's nuclear doctrine is no first use. We will not strike first, but will retaliate massively if struck. SSBN is the nuclear powered submarine armed with ballistic missiles, the most survivable nuclear platform. Three nuclear delivery platforms, land missiles, air bombs, and sea based submarines. K 4 SLBM is the submarine launched ballistic missiles, 3,500-kilometer range. No first use is the India's doctrine. No nuclear first strike, only retaliatory use. Then we have the Strategic Forces Command, which is established 2003, commands all three nuclear triad legs, and Project 17A, seven indigenous stealth frigates built at MDCL Mumbai and GRSC Kolkata. Then we have the Great Nicobar Island Project, the 72,000 crore Great Nicobar Holistic Development Project, comprising a transshipment port, airport, township, and military base, continues to face legal challenges from environmental groups and tribal rights organizations. The project requires felling 8,52,000 trees and involves building a port on Galathea Bay, a critical wildlife sanctuary. Now, Great Nicobar is a UNESCO designated biosphere reserve. It receives international protection as a living ecosystem of global scientific significance. The leatherback sea turtle, Damochelis coriacea, exhibits natal side fidelity. Females return to the exact beach where they were born to nest. The Shompen are a particularly vulnerable tribal group, one of India's 75 most vulnerable tribal communities, with a population of only 200 to 400 individuals. We have the leatherback sea turtle, world's largest reptile, IUCN vulnerable, critically endangered in Indo-Pacific. Shompen is the PVTG of Great Nicobar, 200 to 400 in population, hunter-gatherer. EIA Notification 2006, India's Framework for Environmental Impact Assessment under EPA 1986. Galathea Bay is the primary leatherback nesting site. Location of proposed transshipment port. Biosphere Reserve is the UNESCO designated living laboratory, and ANIDCO is the Andaman and Nicobar Islands Integrated Development Cooperation. Then we have the MLA disqualification and the 10th schedule. Multiple states continue to see MLA disqualification petitions pending before speakers, in some cases for months and years, with defecting legislators voting on budgets and supporting governments while their cases remain undecided. The 10th schedule's structural flaw is back in the news. Under the 10th schedule, added by the 52nd Constitutional Amendment 1985, the Speaker of the Assembly decides all disqualification petitions. The problem is the Speaker is a member of the ruling party, which often benefits from defectors remaining as MLAs. Now, this is an irreducible conflict of interest built into the law's design. Now, there is no constitutional or statutory deadline for the Speaker to decide a disqualification petition. In Quixote Holohan versus Zachilu, 1992, the Supreme Court upheld the 10th schedule and held that the Speaker's decisions are judicially reviewable. but only after the Speaker decides. 10th schedule is the 52nd Amendment 1985 anti defection provisions for Parliament and state legislatures. Para 2 is the grounds for disqualification, voluntary party exit, voting against whip, and independent joining party. Para 4 is the merger exception. Two-thirds of the legislature party members can merge without disqualification. Kyoto Holohan is the SC upheld 10th schedule. Judicial review only after Speaker decides. Subhas Desai case is the Maharashtra crisis. Governor add, Election Commission decides party identity. An anti-defection law is a law preventing elected members from switching parties for political gains. Then we have the transgender rights, NALSA versus the 2019 Act. Reports on the April 4 highlighted the continuing gap between the India's constitutional protections for transgender persons, as established by the Supreme Court's NALSA judgment, and the lived reality of discrimination in employment, healthcare, and housing, with the Transgender Persons Act 2019 drawing continued criticism for contradicting NALSA's core principles. In NALSA versus Union of India, the Supreme Court held that gender identity, a person's internal sense of their own gender, is protected under Articles 14, 19, and 21 of the Constitution. Crucially, it held that this is self determined. No medical procedure, surgical certificate, or official validation is required. The Transgender Persons Act 2019 introduced a certificate of identity process, and for male female redesignation requires a surgery certificate from a medical officer. A 2021 UNDP survey found 96% of transgender persons report employment discrimination, and 71% have faced family rejection. The 2019 Act prohibits discrimination but has no enforcement mechanism, no dedicated investigation body, no proactive monitoring. NALSA versus Union of India 2014 is SC landmark, third gender recognized, Articles 14, 19, 21, self identification. Transgender Persons Act 2019 is the first comprehensive statute, certificate of identity, and surgery certificate controversy. Third gender is constitutional category recognized by NALSA, separate from male female binary. Yogkarta principles is 2006 international standards on gender identity rights, cited by NALSA. Certificate of identity is document under 2019 Act obtained from district magistrate, required for legal recognition. And Hijra community is the India's oldest transgender community, at least 4,000 years old, 4,000 years of recorded history. Then we have the IBC Amendment Bill, fixing India's insolvency crisis. Now, the Insolvency and Bankruptcy Code Amendment Bill for the 2025-2026 proposes extending pre-packaged insolvency to large corporate debtors and introducing a cross-border insolvency framework, addressing two of the most significant gaps in India's insolvency resolution system since IBC's enactment in 2016. Now, IBC 2016 set a statutory CIRP timeline of 330 days maximum, after which a company goes into liquidation. The actual average in 2026 is 650 to 700 days. A haircut is the difference between what creditors are owed and what they actually recover. India's average is 68%, meaning creditors get back only 30 to 32 paisa per rupee of admitted claims. Now, pre-packaged insolvency, where debtor and creditors negotiate a resolution plan before formally filing with NCLT, reduces the processes to 90 days instead of 330, currently available only for MSMEs. The amendment proposes extending it to large corporates, which would dramatically reduce NCLT caseload and improve recovery rates. CIRP is the corporate insolvency resolution process, IBC's core mechanism. Haircut is the difference between admitted claim and actual recovery. Committee of creditors is the financial creditors who control resolution process. Pre-packaged insolvency is the negotiated resolution plan submitted to NCLT. NCLT is the National Company Law Tribunal, And IBBI is the Insolvency and Bankruptcy Board of India, regulates insolvency professionals and the resolution process. Then we have the DPDP Act 2023, India's data protection law and gaps. So, the Digital Personal Data Protection Act 2023, India's first comprehensive data privacy law, continues to await the notification of its rules, without which the law remains largely unimplemented more than 2 years after enactment. The Act's government exemption provision remain the subject of ongoing debate. In case Puttaswamy versus Union of India, a 9 judge Supreme Court bench unanimously held that privacy is a fundamental right under Article 21. The court directed Parliament to enact a data protection law. DPDP Act 2023 is that statutory response. 9 years in the making from the initial Shri Krishna Committee in 2017. Unlike the EU's GDPR regulators, which can investigate, audit, and raid companies, India's Data Protection Board can only hear and decide complaints filed by individuals. It has no power to investigate systemic violations proactively. Section 17 of the DPDP Act exempts the central government and its agencies from the law's obligations on grounds of national security and public order. This means government's programs like Aadhaar, CCTNS, and health records are outside the Act's privacy protections. DPDP Act 2023 is the Digital Personal Data Protection Act, India's first data privacy law, enacted August 2023. Data fiduciary is any entity that determines how and why personal data is processed. Data principal is the individual whose personal data is being processed, has rights to access and erasure. Data Protection Board of India is the adjudicatory body for data protection complaints, not a full regulator. Puttaswamy judgment is a 9 judge SC bench. Privacy is equal to fundamental right under Article 21. And Section 17 exemption is the DPDP provision exempting central government from the law on security grounds. So that's today's 6: Defense Triad, Great Nicobar, Anti Defection, Transgender Rights, IBC, and DPDP. Revise the keywords. See you tomorrow. Thank you.